President Donald Trump's administration has recently petitioned the Supreme Court for authorization to resume deportation flights to El Salvador, invoking the 1798 Alien Enemies Act. This move has ignited significant legal and political debates concerning the scope of presidential powers, due process rights, and the ethical implications of utilizing centuries-old legislation in modern immigration policy. The Alien Enemies Act, originally enacted during the late 18th century, grants the U.S. President authority to detain and deport non-citizens from countries considered adversarial during times of war or national emergency. The Trump administration has applied this act to expedite the removal of individuals suspected of gang affiliations, particularly targeting alleged Venezuelan gang members without providing them standard immigration hearings. This approach has led to the deportation of approximately 140 individuals to El Salvador, raising concerns about the suspension of due process and the potential for wrongful deportations. Legal challenges swiftly followed these actions. District Judge James Boasberg issued a temporary restraining order, halting the deportations for 2 weeks to assess claims that the administration improperly invoked wartime powers to circumvent established immigration procedures. Judge Boasberg expressed skepticism over the use of the Alien Enemies Act in this context, describing the administration's actions as incredibly troublesome and problematic. He noted that the proclamation appeared to have been signed in the dark of night, suggesting an awareness of its contentious nature. The American Civil Liberties Union, ACLU, representing the detained migrants, argues that the administration's actions violate constitutional due process rights. They contend that foreign nationals are entitled to fair hearings before deportation, and the summary removals under the Alien Enemies Act bypass these fundamental protections. The ACLU's lawsuit highlights the tension between national security measures and individual civil liberties, a recurring theme in U.S. immigration policy debates. The administration, however, maintains that the individuals targeted pose significant national security threats due to their alleged gang affiliations. They argue that in matters of national security, the president's determinations should not be second-guessed by the judiciary. This stance underscores a broader effort by the Trump administration to expand executive authority in immigration enforcement, often at the expense of traditional checks and balances. The appellate process has further complicated the issue. A federal appeals court upheld Judge Boasberg's order, with a divided panel reflecting the contentious nature of the case. Judge Patricia Millett, concurring with the decision, remarked that Nazis got better treatment under the Alien Enemies Act, highlighting the perceived severity of the administration's current application of the law. This statement underscores the profound ethical and historical concerns surrounding the use of such legislation in contemporary contexts. In response to these legal setbacks, the Trump administration has escalated the matter to the Supreme Court, seeking an emergency appeal to vacate the restraining order and reinstate the deportations. This move is part of a broader strategy to push the Supreme Court to endorse expanded presidential powers in immigration enforcement, potentially setting significant legal precedents for the future. Critics of the administration's approach argue that invoking the Alien Enemies Act in this manner sets a dangerous precedent, allowing for the erosion of due process rights under the guise of national security. They caution that such actions could lead to the targeting of individuals based on nationality or perceived affiliations without sufficient evidence or legal recourse. Moreover, the use of a law with historical ties to periods of xenophobia and wartime paranoia raises concerns about repeating past injustices. Supporters of the administration contend that swift action is necessary to protect national security interests and that the traditional immigration court system is ill-equipped to handle cases involving individuals suspected of gang involvement or terrorism. They argue that the president must have the flexibility to act decisively in the face of emergent threats, even if it means bypassing standard procedures. This case represents a critical juncture in the ongoing debate over immigration policy in the United States. The Supreme Court's decision will not only impact the immediate fate of those currently facing deportation under the Alien Enemies Act but also set a precedent regarding the balance of powers between the executive and judicial branches in matters of national security and immigration. As the nation awaits the court's ruling, the case continues to evoke deep discussions about the principles of justice, the rule of law, and the ethical responsibilities of a democratic society in handling immigration and security challenges.